During the November 2018 general election, Michigan voters approved Proposal 1, making Michigan the 10th state in the nation to legalize marijuana for recreational purposes. As of December 6, 2018, people 21 years and older can possess, process, and consume up to 2.5 ounces of marijuana. They can possess 10 ounces in their home, and they can grow and process up to 12 plants. I'm Delaney McKinley, MMA Senior Director of Government Affairs and Membership, and I've heard a number of questions and concerns from our manufacturing members about how legalization of marijuana will impact their operations. In today's webinar, we have two acclaimed professionals who will help you better understand your risks and responsibilities under the law and develop strategies to protect your company. I'd like to introduce our esteemed guests. First, we have Megan Brown, Vice President of Sales and Marketing for the Manufacturing Technology Mutual Insurance Company. And that's a leading provider of workers' compensation insurance to Michigan's manufacturers since 1976.
Thank you.
Thanks for being here today, Megan. And we have Kurt McCammon, a principal with Miller Canfield. And Kurt's also a previous law enforcement officer and undercover narcotics officer. So he's got particular area of expertise in the drug law. And Kurt's also ranked among the top labor and employment litigation professionals in the nation. So thanks for being here today, Kurt.
Thank you, Delaney.
My first question is for you, Kurt. How has the adoption of Proposal 1 affected an employer's ability to maintain a drug-free workplace?
Delaney, the good news is there is limited or no legal impact on an employer's right to govern what happens in the workplace regarding marijuana. Employers are still free to have a zero-tolerance drug-free policy that prohibits use either on or off duty of marijuana. It didn't change Michigan's Medical Marijuana Act, and marijuana is still illegal under federal law.
So you can still hire, fire, discipline as you see fit for your workplace?
Yes, provided that the discipline or termination is done consistent with policy, and I would say it should be a well-written and well-understood policy, and it also has to be consistent with any relevant collective bargaining agreement that may be in existence in a union setting.
And that's particularly important for some manufacturing employers.
Absolutely.
Now, given that understanding, there are, in practicality, some very serious implications here. Megan, is that true?
Sure. For many Michigan manufacturers, finding talent is already a difficult task. And with the passage of Proposal 1, that task has just become that much more difficult. It's actually exacerbated and added additional challenges for hiring and managing your workforce, as well as controlling risks within your own place of employment.
Absolutely. Kurt, I'm a lobbyist, and I work in the area of HR law, so I'm not an attorney, but I know enough to be dangerous. There are a number of other legal requirements and responsibilities that employers have that they need to consider in their decision-making here, right?
Yes, there are. And if they fail to live up to the responsibilities, it can equal legal liability. For example, there is an obligation on the employer to maintain a safe workplace for the employees. If they condone or otherwise overlook the improper and inappropriate use of marijuana and it results in injury to a worker, that could come back to haunt them. There's also third-party liability, defective products, car crashes by people who are employed and are involved in such things while under the influence or impaired by marijuana could lead to liability. There were also issues involving home office and remote office locations. The employer should make sure that they're monitoring what is going on in these home or remote offices and make sure that there is not inappropriate use of marijuana or that their employees are not under the influence in those situations.
Sure. Now, manufacturing facilities tend to have a greater number of safety-sensitive positions than other employers, and I understand that the data is kind of mixed nationally on the correlation between legalization of marijuana and accident occurrence. But it stands to reason that a less sober workforce is going to have a greater propensity for accidents. How does this impact workers' comp, Megan?
So in terms of workers' comp, the way premiums are determined is we would take the payroll from a particular company, and it's segregated by class based on what the duties that the employees are providing. and there's a calculation with rates that are filed by a particular insurance carrier, and then there's an experience mod. And an experience mod is a 3-year history of claims that a company has in their facility. And so if you have an increase in claims in terms of severity or frequency, that's going to increase your costs in terms of workers' compensation insurance. So it's very important for an employer to try to control those costs and control their claims. So, some of the things we've seen is that an addicted employee tends to not only abuse drugs, but they abuse the workers' compensation system as well. They tend to malinger, they stay off work longer than the injury would normally dictate, and they miss appointments. And all of those things are going to increase the cost of a claim, which then rolls up into costing the employer additional money as well. So it's interesting, we've seen that some states have decided that if you can attribute the injury to someone being under the influence of drugs or alcohol, that they have been able to deny a claim or reduce the indemnity benefits by a percentage. Fortunately, unfortunately, that is not a case in Michigan at this point. So, and we have seen a few states that allow medical marijuana as a treatment for workers' compensation insurance, where they require the insurance provider to actually reimburse the cost of the medical marijuana for the treatment and the workers' comp claim.
But so far, not here in Michigan.
Not here in Michigan, absolutely.
Yeah, and actually MMA was involved in legislation to make sure that that was not required of employers. So we want to maintain that kind of flexibility for, for employers.
Absolutely.
Now, I mentioned that we've received a number of calls from employers who are concerned about how they can protect themselves in light of all of these things that we've talked about. Kurt, where should they start?
They need to address the issue head on. They need to understand the practical and legal implications of the passage of Proposal 1. They need to review policies, make sure that the policies say what they want it to say and reflect the company or the organization's position on it. They need to, I think, communicate what those policies are and have discussions. And in many respects, they need to tell their employees and understand themselves what they will do if there is a positive test response.
Okay.
I think that they should also consult with legal counsel along the way to make sure that all of the legal issues are being addressed as they revise or write policies, communicate what those policies are, and train on those policies.
Now, that's a lot to consider, so let's take it one piece at a time. Let's start first. You had mentioned establishing kind of a general approach to how your company is going to approach drug use.
Yes, it begins and ends many times with the wording of a policy. The company needs to make sure that their policies are correctly written, that they accurately reflect the position of the company on marijuana or medical marijuana, as the case may be. As I said before, the law does not require an employer to accommodate or to allow the use of marijuana on or off duty. However, what you need to do is make sure that the little details are not missed. For example, many policies written long ago used to refer to illegal substances and prohibit only those which were illegal. With the passage of Proposal 1, marijuana is no longer illegal under Michigan law. You need to say clearly in your policy, we prevent or prohibit the use of illegal substances and marijuana. Don't beat around the bush. Say exactly what you mean. In addition, you need to address things like not only the smoking of marijuana, but you need to describe other uses. Marijuana is now eligible to be used in many forms. You can consume it in many ways, including through edibles. Your policies need to address these differences in how marijuana can be used.
Absolutely. You know, it's an important point for employers to keep in mind is that the levels of THC in marijuana has changed over the years. They've gotten higher, and what that means for employers is that highs last longer. And employers definitely need to be aware of that. And you know, in terms of insurance, your costs go up as claims occur, so you definitely need to have a policy in place, as Kurt mentioned, that focuses on one way that an employer can control the costs is by having a strong policy that eliminates or doesn't permit the use of marijuana on the premises or during work hours, and that would be part of their strong risk management program. Claims cost money, and hopefully not somebody's life or limb.
Absolutely. Now, there are a couple different terminologies that I've heard with regard to different policies. One of them is a zero tolerance policy, or a second chance policy, or last chance policy. In fact, and we're hearing more about the second chance idea. In fact, Indiana just last year passed legislation that was supported by the Indiana Manufacturers Association that kind of sets the legal framework for a second chance policy. So basically what it does is allows for easier access to substance abuse treatment. It allows employees to actually contribute from via a payroll deduction for treatment services. And it provides a level of protection from liability for employers that employ these kinds of policies. What do you think about these types of policies?
Actually, MTM recommends a zero tolerance policy,
Okay.
and it is certainly the easiest method of enforcement for employers today. In terms of the second chance policy, we've heard that more or less used for prescription drug use rather than marijuana, but it does need, a second chance policy does need to be closely monitored.
Okay.
If an employee wants to invoke the second chance policy, they do have to complete a substance abuse program, as you mentioned, and be closely monitored to make sure that they're staying in compliance with the program. And it's very important that the employer spell out the discipline program, regardless of whether it's a zero tolerance or a second chance policy, so that all employees are clearly aware of what the consequences are of violating the policy.
Absolutely.
I agree with Megan. I would also say I think there are pros and cons to a second chance or last chance policy.
Okay.
The pros, of course, you may very well, if the culture allows, be able to salvage a valuable employee. It's compassionate, it's looked upon as fair. Many employers, however, will choose to enforce a second chance or last chance policy only in favor of one who is considered to be a valuable employee. And if the employee is marginal, they may try to use the positive drug test to separate them from the company. That can clearly lead to discrimination or retaliation claims. The same is true, we have a saying in law, and I've been a litigator for now about a quarter of a century here, no good deed goes unpunished. And that can be true with these kinds of second chance policies. The federal law under the American with Disabilities Act is that the current use of drugs is not considered a disability, it's not protected. However, if I go through a rehabilitation program and the employer keeps me on pursuant to one of these policies, then the employer is saddled with the knowledge that I have been in the past addicted or a user of some form of unlawful substance, including marijuana, which could be unlawful under the policy. That means once the employer is saddled with that information, any decisions they make in the future against me, even if I fail to perform and I'm separated from the company, that employee who has gone through the rehabilitation program may use the knowledge against the company and bring a retaliation or discrimination claim. It can be done, but it must be done carefully and it must be applied consistently.
So we have kind of a confluence of different areas of the law that really need to be considered here.
Yes.
Let's move on and talk a little bit about drug testing, because that also gets very complicated. Let's talk specifically about pre-employment drug testing. Megan, you had mentioned that, and we hear this all the time from our members, the #1 barrier to continued economic growth within Michigan's manufacturing industry is the availability, or actually lack thereof, of skilled talent. And I hear anecdotally from our members all the time about the difficulty of getting applicants to pass a drug screen. So should manufacturers continue to do that pre-employment drug screening? Can they afford to turn a blind eye?
I would say absolutely they can't afford to turn a blind eye. All manufacturers have safety sensitive positions in their facility, and they can't risk having an employee impaired at any level. So a drug testing policy I feel is absolutely necessary. An employer can control unnecessary claims by having a drug testing policy in place. Again, as I mentioned earlier, an increase in claims, whether severity or frequency, is going to increase the factor that is used to determine your workers' compensation insurance premium. So One thing I think for employers to keep in mind is that if they do have a zero tolerance policy or a drug-free workplace policy, many insurance companies will give you a discount on your workers' compensation insurance premium. And a lot of times that discount that is applied would help cover the cost of putting the drug-free workplace policy in place.
All the more reason to be reviewing your policy, making sure that's in there.
Absolutely, absolutely.
I understand that there are a lack of qualified employees, especially in what seems to be a very good employment market. The employer, however, has to balance the short-term needs with the long-term ramifications of hiring too quickly and of not drug testing. You have to understand as an employer that once hired, that employee's problems become the employer's problems. And we would recommend that you continue with the pre-employment screening because that lets you know what you're facing. It doesn't mean that you have to disqualify that employee, but it puts you on notice of what potential problems may be, and you're better able to address them if you know what you're facing.
So you know what you're accepting into your company.
Exactly right.
Sure. So what about your current workforce, Kurt?
Drug testing for the current workforce is entirely recommended. Now, there are several types. We have after incident or after accident testing. We have random testing, and we have reasonable suspicion testing are the three most prevalent or prominent types of testing in the workforce for incumbent employees. Each company, we recommend, looks at their particular situation. Do they have problems in these areas? Is it potential there? Does it exist for those problems? And if so, then you need to devise the testing around these problems that you may face. If you're going to use reasonable suspicion testing, you need to train your supervisors and your key employees on the detection of use of marijuana in this case, or other unlawful substances. You need to train them how to investigate, how to document, and how to be able to relate that information to an arbitrator or a jury if there is a case because you have terminated someone and they file a claim or a lawsuit. It's entirely appropriate to train your workforce. And I'm talking about the folks who may very well be charged with violations of this policy. Give them notice ahead of time of what the requirements are, help them meet the standard, and then be ready if they don't.
Yeah, I think that's a really important point because I wonder how many employees are out there thinking that now that this is legal, I can do it whatever I want and there won't be any ramifications. They need to know that there will be if that's appropriate in your workplace.
Absolutely, and we have recommended to our employer clients that they send out a notice, and many of them did shortly after the election, before the marijuana law took effect on December 6th of 2018. And we said, just tell them, we know that the law has changed. Our policy has not, and you will be held accountable.
Sure. Megan, I know that MTMIC provides a lot of assistance to policyholders in this area. Do you have any experiences that you've all seen that might be maybe some pitfalls that employers should work to avoid, or things they should consider with this area?
Sure. The big thing is to make sure, as Kurt mentioned, that you're consistent in terms of testing your employees. Doesn't matter whether they're an hourly employee or management, they should all be subject to the same test. If you're doing injury care, if you're testing when somebody has a work-related injury and you're going to do a 5-panel test or a 10-panel test, doesn't matter whether you're the owner of the company, manager, supervisor, or you're an hourly employee. Testing has to absolutely be consistent. Sometimes what we have seen is some on-site testing. There are instant tests where a company may have an employee supervisor approach an employee and tell them to collect their sample and return it back to the supervisor, and the supervisor is the one that interprets the test. Not something that we recommend and should definitely is not a good idea on many levels. We recommend that in terms of testing, you have occupational health clinic or facility know what your policy is, know what drugs you want tested for, regardless of the reason, whether it's post-accident, random, reasonable cause, as Kurt mentioned, and make sure they enforce your policy or implement it consistently.
Great information. Now, if you're a manufacturer and you've reviewed your policies and you've made the necessary updates, what's next?
Communicate those policies. make sure everybody understands. Train your employees, train your supervisors, train your key employees. Make sure that in this day and age, you do communicate very clearly to your workforce that even off-duty use can violate a zero tolerance policy, and the company will take disciplinary or up to including termination action if the policy is violated. In order to be effective, a policy has to be well written and well communicated.
Absolutely. Megan, do you have any thoughts?
I want to reiterate the point about the supervisory training and the importance of that. I mean, the role of the supervisors, it's essential that supervisors are trained, and the goal is for them to implement the policy and enforce the policy as the employer deems appropriate based on the level of testing and different things. So, and I think that is, besides having a clear policy, I think you definitely need to train your supervisors to make sure they know what the expectations are for them.
Kind of that idea if a tree falls in a woods and no one hears it, what kind of impact does it have?
Correct.
Absolutely.
Correct.
Well,
Yeah.
I know that we're running a little bit short on time, so I'd like to shift our attention to the future. Now, because this was adopted on the ballot, Michigan's Constitution requires that the ballot proposal only be amended by a three-quarters vote of the legislature. And we know that that's practically an impossibility. So we don't really expect to see much, if any, legislative activity on this front, but how about legal activity? Do you expect to see anything?
We're in untested waters here. We know that Michigan's law is written a little bit differently than the law in other states. The initiative that led to the passage of Proposal 1 specifically said that employers need not accommodate or tolerate marijuana use in the workplace or off-duty. Other states have different laws. There has been substantial litigation, and the courts have been asked to decide many of these issues. We'll wait, we'll see how Michigan's law is interpreted and whether or not it's changed. I would also recommend that employer clients follow the federal law. There seems to be some softening in the position of federal law, which, as I said before, still says that any possession, use, manufacture, or delivery of marijuana is illegal and subject to severe sanctions. Lastly, I would suggest that our employer representatives contact their legal counsel, stay in contact with them, and make sure they know what's coming so they can anticipate it and be prepared.
Great, thank you.
I'd say in the meantime, so you're not a target of one of those lawsuits that Kurt has mentioned, make sure you review your policies, implement them consistently, and communicate them clearly to your employees.
Absolutely. Well, thanks so much to both of you for being here today.
Thank you.
We really appreciate you sharing your expertise with our viewers, with our members, and with us today.
Thank you.
MMA will continue to bring you educational resources like this webinar to help you comply and protect your company. MMA's new Drugs in the Workplace Task Force will also be an opportunity for members to get the latest updates, to share best practices, and work together to support and defend the industry from this emerging and growing threat. We thank you for being here today and hope that you won't hesitate to contact any of us directly with questions or concerns. Thank you.